Private living, Rio, Federative Unit, Rio, national state with problems as misuse by criminal purpose at state and institutional power is the Brazil, in solidarity with peer by purpose at wrongdoing and continuity of issues international complaint since at least 2014, with distortions observed maybe since 2002 as violation of civil rights, systematic violation of guarantees, basic rights, everything systematically made, which implies no excuses. We will have our effort with the camera at the mobile too, because we are having problems all the time, kind of as cutting energy and things like this. Now we are at the mobile and also at the machine that has no access to the internet. We will read that we on Saturday, October, we offered from private living and totally inside privacy as space, including social media, conclusive evidence or proofs systematically made as traced to trace violation against basic rights and guarantees. At this way, requesting here this crime system by heads leading abusive procedure and institutional crimes that hurt guarantees and try to steal elements on privacy, right? Including the intellectual asset that goes in the same way as a picture that you didn't post it. Judicial storage, all values, 39 trillion, plus the cases, fees, and all other elements. Research or review, this time a review, and more prisons against the institutional crime, targeting the association from the crime system Brazil that is used as a criminal driver some way. Request. Today, Monday, considering the integrated criminal practice on Brazil public system, proved as transnational organized crime, especially on budget that became the budget, and having at this segment public the major of criminal system Brazil, the major offender against basic rights, guarantees, or all legal interests hurt or affected by this crime system, we request have recognized 1. The crime system and practices, including the banking and the international financial system, complained since 2014 by the OECD, IMF, and UNODC. It's the United Nations Office about Drugs and Crimes and Corruption, Drug Use, Prostitution, Piracy, White-collar crime, and all things complained that the institutional power is illegal. Number 2, all issues complained, because indeed they are all facts notoriously proven, and many of them in Blazing Act, especially the misuse of power by no dispute. Apply all consequences affordable or valid. We will check that the Brazilian law has a quite clear line on Article 84, 85, 84, saying that the presidential chair will do the designation of their Ministry of State. In general, are ministers that will help them. But they do also the Supreme Court and all other superior courts. And they will do not the Supreme Court, because their duties on Article 102, but they didn't accomplish. we will observe that the presidential chair plus the ministry are kind of the CAO and the board group, and you must satisfy some way the investor, since this microarchitecture, even inside a global company, do not run things in a criminal way or purpose. The clause number 8 says that this presidential chair will do international agreements like the Security Forum. And the clause number 7 says that it will keep this chair the relation with the international community. And the number 6, clause number 6, A and B, that this chair number 1 will do the organization of the public administration, right? So they do the designation as top level, as their board members or peers as Minister of State. Also the Supreme Court do the institutional design of the public administration. And on Article 142 says that the military force go by his hands as chair number 1, right? It's the Constitution, it's literally told. And says that crimes of responsibility, that indeed is not crime because it's not having the punishment as a prison or something like this, but the wrongdoing. Number 1, it acts against the federation. The free activity of the power as Congress, the justice, the prosecution. Number 3, it's about civil rights and individual rights and guarantees. Number 4, the domestic tranquility, that has problem on Article 144. I think that is the security system, that is a mess, and of course cooperating with the criminal organization. And here you have no lines about the chair number 1 except as the institutional design of public administration, but in general they got the chair by a public contest, right? Number 5, the integrity of the administration implies the transparency. Number 6, the budget law that's created by the chair, as the presidential chair and the Congress. Number 7, the accomplishment of the law and judicial decision, since the law not made by criminal purpose and the judicial decision not made by a group as council of peers running a criminal system, right? And after we have this, we will observe that if this architecture made mistakes and those mistakes are viewed by the criminal system as institution and state with physiological argument as immaterial thing, the power that you can touch but you can feel and know they exist, and you feel that is illegal when things go against your rights and guarantees and hurt your interests at the present, changing the past, projecting things combined to the future that will be something very harmful. For instance, if you do a judicial decision considering, and you are the top chair at the court, that will attach the entire system, that allow the bank to take the fixed asset in case of debts. But the individual debt, just microeconomical agent, couldn't pay the television, and they will lose the house or the fixed asset, and they in general they will not pay a lot of things. And why do you consider that they will pay the tax as public debts they have? They won't gonna do this. It's a concept named propter rem, which implies that fixed asset in general, the debt belongs to the things. and it will be transferred to the bank that after receive the property as fixed asset with a corrosive argument as the debit will be obliged to do the payment for the criminal system, right? And the bank will be kind of 2 times the headache, which is charge and request the payment as microeconomical agent that got the credit, used it and didn't pay it as microcredit. And also the integration as asset, which implies, for instance, all debtors at the criminal system transferring the fixed asset to the bank, it's the macro credit plus the public debits that are unsolved. And by this, the combination of both collinear at its honesty allows first responsiveness. The international currency, like the US dollar, will be more expensive in Brazil, for instance, if it's running this scam. And then the banks will raise the rates because it's a natural defense of the bank system. And all these things creating a harmful situation even by risk. It's an Article 37 of the Brazilian Constitution, literally told, as all others, that I think that the public administration will have some, premises as following the law, not personal judgment of things, the morality, have transparency of acts, and efficient. We do not observe rational use of resources, and they have no transparency. The morality is kind of low, below the belt, and they are kind of doing self-dealing all the time, including the piracy and fraudulent scams on real estate market and public budget, white-collar crime, and how they will follow the law. It's a question. And now paragraph number 6 is told that in general, those institutions as the person as public person, which is the moral entity as public institution, and also the peers as public as corporate moral entity as institution doing public service that has the dignity of the public service, that shouldn't be confused with the dignity of the element doing the public service, in the same way the dignity of the justice do not deserve be confused with the dignity of the judge, especially by criminal use of power. And in this case, they will do the satisfaction of the consequence in solidarity with the institution by the regression made, for instance, using this paycheck. It's told. It's not my words. It's the Brazilian Constitution. Then we'll check now the final thing. That the idea is quite simple. I will observe that I have my financial system Brazil and was complained by the OECD that has internal failure as misuse of credit. This means we will observe that the relation debit and credit, we will have the source that can be treasury or saving account of companies. The difference is how the income will be made. The saving account will be made by the year 173 of the Brazilian Constitution. The state can do economic activity. The treasury in general by taxation. So here I have tax, here I have the work, resulting something, and this will be kind of the relation of debit and credit on both. because the debit and credit is in the very first moment the same thing, but will be divided as corporate debt by the misuse of credit, or public debt by misuse of credit. Transferring them both to the outside, we will observe that the quality of the debt, not talking about the responsibility yet, will have, in the way we are observing and following the requirements, I would say, on our diary, Monday, day 30, is it okay? Have recognized, 1, the crime system and practice, including the bank. The quality of this debt, is it showing any risk here? Criminal system. By the decision and architecture of power, presented as corrupted and unveiled with criminal purpose. Guarantee 33 of this credit as international guarantee, observing the Article 4, which is the commitment of the Brazilian Republic with the international community. After having this, that you will lie or do not answer the question, we suggest to consider offer public bonds as sovereignty bonds. But how can you offer the sovereignty bonds without the sovereignty? I think that you are naked, Brazil. Like Indians in the past, right? Have a great week. Dollar, US dollars, real, not fake currency, will be more expensive. Bank rates, for sure, the natural defense will skyrocket. And the consequence as harmful situation with regression until the chairs doing this in solidarity with institution. Article 37, paragraph number 6. Right? We take a look on our constitution one more time and finish the presentation. Very helpful today, I bet. Guarantee number 41. The law will do the punishment of discrimination against rights and the fundamental elements of freedom, including the Article 9, the free expression of intellectual activity, delivered as pro bono. Right? I think that's told by the Constitution. And says that the House has no excuse to be broken by the abusive procedure, and the secrecy of issues as data also. Have a great day, Brazil. I bet it will be terrific, end of year. And Merry Christmas.